Lawsuits are complex, but the right birth injury lawyer can walk you through the process. One of the first things that's done in a birth injury lawsuit is compiling all of the medical records, the diagnostic tests, every bit of information from the doctors, the hospitals, the nurses, etc. That takes a large amount of time to compile. Over a series of months, that's done. After that's done, then the lawyer and their in-house paralegals will review it. If it passes that first muster that there has been some sort of potential for medical negligence, then in Illinois, it's required that every lawsuit that's filed against a medical professional has an expert that specifically reviews all the documents, and it has to be an expert doctor in that field. That doctor has to make a determination that there has been some sort of medical negligence and provide an affidavit to the court which details exactly what the medical professional or professionals did wrong, or the hospital did wrong, or the nurses did wrong, and then file that with a complaint. So if there's been a determination that there's been medical negligence in a birth injury lawsuit, typically a complaint is filed, and the complaint is filed in the county, typically where the negligent act or acts occurred. After that's done, the defense will appoint lawyers to represent all of the defendants. After that happens, there's usually an initial conference between the attorney for the injured party and the family. So the family lawyer will talk with the lawyer or lawyers for the defendants, and they'll talk initially, hey, is this something that we can resolve right away? We believe that there's been medical negligence here. Would you like to resolve this and do the right thing and make sure that we come to a conclusion so the family doesn't have to go through all of this? Typically, that doesn't work out, but it's worth a try initially to lessen the amount of damage that's done to the family, as far as making sure that they don't have to go through a process which is going to be lengthy. And we're talking about typically years of litigation. So the lawsuit's been filed. There's been an attempt to resolve the case, and say that doesn't happen. Well, then there'll be an exchange of what we call written discovery, which mean interrogatories, production requests, and notices of deposition are sent out to the defense. The defense also sends them to the plaintiff, and typically the plaintiff, usually is the mom and dad, will be deposed. The defense will actually want to have the child examined, find out exactly what the damage that has been done to the child. Usually they'll already know that because they represent the doctors that were involved in the initial treatment. That'll happen, and then there'll be a number of depositions of the defendants. So usually all of the folks that were involved in the delivery, all the folks that were involved with diagnostic tests, all the folks that were in the NICU, those types of things. After that's done, then there'll be a number of depositions of experts. And these are experts that will actually testify on behalf of both the plaintiff and defendants. And usually in these cases, that can be anywhere from 5 or 6 apiece to 10 apiece. So you're looking at 10 to 20 depositions that'll go on. After that's done, then usually a trial date is set. So there'll be a trial on the matter. Typically, the parties will have a mediation in between, where there'll be a judge or a retired judge that will get the parties together to see whether or not there can be any settlement made between them. And if that works out, that's great. If that doesn't happen, then there's a trial. And usually these trials last anywhere from 2 weeks to 2 months. And that involves the testimony of the plaintiff, parents. Usually the child will be seen by the jury. There'll be family members, there'll be caretakers, there'll be life care planners, there'll be all the experts on liability, all the experts on damages, and then there'll be the experts on the defense side, as well as all the parties on the defense side. After that's done, then there'll be closing arguments for the jury, where the lawyers, the birth injury lawyer, will tell the jury exactly what they believe that has happened in the case, and the defense lawyers will say the same thing. And then the jury will deliberate, and they'll make a decision on economic damages. They'll make a decision on non-economic damages. But more importantly, they'll make a decision on liability. Was there liability in the case? If there was liability, then they'll get to damages and determine the amount of economic and non-economic damages. After that's done, there'll be a verdict read by the court, and there'll be a judgment entered, either a judgment for the plaintiff, which will say how much money that is owed by the insurance companies, or there'll be a judgment for the defendant. And After that happens, then the court will enter the judgment. Either party can appeal that ruling within a certain amount of days. And if that happens, then there's an appeal, and you go through the appellate process, which usually lasts 1.5 years to 2 years as well. If you'd like a free consultation regarding this very sensitive matter of a birth injury case, feel free to reach out to us at 312-578-9501. That's 312-578-9501. If you'd like a free book on cerebral palsy and medical negligence cases, just text the words cerebral palsy to 312-847-2428. That's 312-847-2428, and we'll send you out a free copy of our new book.